This week I'll be discussing contract discharges and damages. I was the teacher, Ben Worsley, and I taught my mother, Kim Worsley, on today's date of 10/13/2021. Here's a brief outline of what's going to be discussed. We're going to start with the discharges, which are full performance, substantial performance, breach or non-performance, anticipatory breach, conditional discharge, agreement, and operation of law. After that, we will discuss damages, and those include compensatory, consequential, liquidated, and punitive damages. And then to finish things off, we'll discuss some of my personal takeaways and questions that Kim had for me. So to begin, we'll discuss discharges. Full performance is pretty obvious in nature, as you would expect. If the terms of the contract are fulfilled, then the conditions will be paid and the contract will be over. There's nothing else to it. The next is a substantial performance. A substantial performance has to be done honestly and sincerely, with any variance that happens to be within reasonable terms and leaving the end result essentially similar to what a perfect condition or a complete performance would be. And so an example of that would be like this person in the picture here, modeling a kitchen. If someone were to scratch the backsplash behind the sink or nick the crown molding at the bottom of the wall and some slight little damages like that, but the rest is all looking really good and they did their best and they really tried to do the job to the best of their ability, then that would be considered substantial performance. And so the contract would be fulfilled and therefore discharged. Furthermore, there's breaches or non-performances. And a breach, as we know, it is when one of the parties neglects part of the terms and therefore makes the contract void in nature as of that point. And then, of course, non-performance, if one does not do as they said that they would, then the contract is voided as well. Anticipatory breaches are when a person or a party indicates that they will not be able to fulfill their contractual obligations. Something that is good to know is that it needs to be explicitly clear for it to go over well when you claim the breach in court, and then that this can be done immediately after the person indicates that they will not be able to meet their obligations. And an example of that would be like here with these mechanics. If they agree to have your car finished by the end of the month, and then 2 weeks before the month ends, they say that they will not be able to finish your car, it'll take a little bit longer. At that point, they have anticipated their breach of the contract. And so at that point, the non-breaching party could seek remedies, which would be equal to the amount of another mechanic and what they would charge, the difference. But if it were to be less than what was originally charged, then there is no remedies there. But something that's really, really, really key to the anticipatory breaches is that it has to be explicitly clear. Good strong words like will or will not are important here. Like in the example, we will not be able to fix your car by the end of the month. So if someone were to say we might not, then it's more of a doubt. It's not them anticipating a breach. So you have to be very careful with the wordings and when you're going to take someone to court on that. Furthermore, we're going to discuss conditional discharges, and there are 4 of those that we will discuss. those that are expressed, implied, based on precedent, and then those that are subsequent. So with expressed conditions, those are those that are written into the contract that you have signed and that you've looked over and that you can actually read out what those conditions of your contract are. Implied conditions are what are expected from past experiences between the two parties. So if you're used to having things done beforehand, before doing a certain job, then, and that's not written into the contract, but it's always been that way, then that's going to be implied. Then with precedents, this is when there's a performance after something else happens. And so an example of that would be to pay for something after you've received your loan from the bank or the government or whatever. So you're not going to do anything until you've received that loan. And then lastly here, subsequence is when a certain condition terminates the existing duty that is being performed. And so a good example of that is to consider like a nanny or a babysitter. So this person takes care of the house or the children while the parents are away. And then when the parents come back, the contract is finished, and generally the parents will pay the nanny for the time that they spent taking care of their children. And something that's interesting is that the most common conditional discharge is between the sale and purchase of a house. So they'll normally put in their contracts a conditional clause that says, I'll buy your contract, your mortgage, once I've been able to sell my own mortgage. That way I don't have to stay with 2 house payments each month. Discharge by agreement. So there are 3 types that we'll discuss here. The first being mutual rescission. And this is when both agree to end the contract. So things may not be working out and the two parties come together and say, okay, it's not going to work out. Okay, that's fine. Let's just forget everything happened, or just stop what we were doing. And then both go their ways and everything's fine. Then furthermore, there's the waiver of rights, which is you give up a right without releasing the other party from the contract. And so an example of that would be to turn in your homework late. You agreed to turn in your homework on time, but you weren't able to. However, the professor waives your a right by allowing you to submit late, despite not being within the contract. And then the last will be novation, which is when one of the parties is substituted by someone else to perform their job. And this can be very practical in a lot of different cases. And then the last discharge we're going to discuss is operation of law. And so with this, when someone dies, their contracts are voided. Incapacity, like if you're had a mental illness or a serious injury or something of that nature, or something that makes you not able to perform the terms of the contract, will void that contract. Destruction of a necessity, that would be like, oh, you don't have a tool to perform a certain job, so you're no longer contractually bound anymore. And then of course, obviously, if whatever the contract is written about is based on illegal terms, then it can't be enforced by the courts. And then something that's interesting is impracticality. And with the I Center in particular on campus, the contractors that agreed to build the I Center drilled holes in the ground looking for lava rocks. And where they drilled, they found no lava rocks. But once they started preparing the land to build the ice center, they did in fact find some lava rocks underneath where the foundation would be. And the price of the building to the contractors would be exceedingly more. And it made it to where if they were to continue, their business would run bankrupt. And so the two parties came together and they discussed the findings, and they made a new contract after that. So the impracticality of the finding of the lava rock voided the contract because they wouldn't be able to do it. But now let's get into some of the damages that people can seek remedies for. The first we will discuss is compensatory damages, and this is paid to make the non-breacher whole. So an example of this would be is, you got injured, and so by someone else's negligence or by someone else's acts on purpose or whatever it may have been, and you sue them and they pay your hospital bills or whatever damages you suffered just to make you whole, like as if you were in the position you were before the event had taken place. With consequential damages, this is the additional damages that come as a result of a breach. And so this is like an accountant that malpractices. So they don't do their bookkeeping, keep up with all that they are doing correctly. And so you get filed some fees by the government and you have to pay those. And then you have to try to seek a new accountant, and there's all those fees that you have to pay. And so you could sue the accountant and then get the damages that came from their malpractice. Now we're going to talk about liquidated damages, and these are agreed upon amounts, usually because the damages are difficult to ascertain. And one of the contracts, not one of the contracts, well, yeah, it was a contract. A case that was submitted just recently about a cancer lab from Boston. The cancer lab was destroyed, and one of the researchers' life's work was within that lab. And because there was a breach in contract with the researcher and the parent company, the company was forced to pay the researcher for all the loss of the life work of the researcher. And it was resultingly astounding how much money it was liquidated to be. And it was about $10 million. And the two agreed in court, and that's what was decided to be the amount of damages that the person suffered. And the last damage we're going to discuss is the punitive damages. And punitive damages are deterrent fees that would motivate others to not commit the same particularly bad behavior that the person being sued committed. And so that was like one of the insecticides recently. The insecticide was causing some people to have cancer. And so when they sued the business that made insecticides, people would get the punitive damages, and multiple people received millions of dollars because of the cancer that they were facing, and just how horrible that the business was for putting a cancerous agent out into the market and doing damages to people. So this fee is paid because we don't want other businesses doing the same sort of thing. And lastly, here are my takeaways and the questions that Kim gave me. So my first takeaway that was pretty big was that one can seek remedy immediately if someone anticipates a breach. I really didn't know that you could do that. Like, oh, I'm not going to be able to do it. I didn't think that that was reason enough to take someone to court, or to be able to be paid for the differences, like between prices because you expected something to be done and you had to find someone else. That's just really nice for a lot of things that unfortunately happen in our society. The second one is that one can discharge a contract because of impracticality. I think that's nice too because crazy things happen all the time and you can't foresee everything. So when those things come about, there's a way for you to protect yourself and you don't just end up uh, burying your own grave, so to say. And then my last greatest takeaway was that damages can be cumulative. So you could get a mixture of compensatory damage or consequential damage or liquidated damage or any of these damages. You could add them up. You could take from multiple categories of damages depending on the nature of the act that was done against you. And I think that's very considerable considering a lot of the bad things that happen to people and how it leaves their life afterwards. But my mother had some questions for me. She asked what punitive means, and it basically means to punish. So a punitive damage is punishment damages. And then what is an example of giving up a right without releasing someone from their obligations within the waiver of rights? And an example of that is like what I said with the late homework. You agree to turn in your homework by a specific date. If you don't, then you get a 0. That's the contract. But then if you were to talk to the professor or your teacher and say that you're not going to be able and you try to discuss why you can't and then like what future steps might be and you agree that you can indeed turn the homework in late and it will be accepted, then you're waiving the right, but you're not removing the person from the contract. So you may give them an extra few days or they accept a deduction of points from their grade. So that's an example of waiving one's rights, but keeping them within the contract. But I learned a lot about contracts and their discharges and damages, and I was grateful for this opportunity to teach Kim this week.